Did you know what is meant by judicial notice? As one of the famous terms always made by people. Example, the court took judicial notice of Depot, a cultural right performance by the Kobo State. What does it therefore mean to say judicial notice? Well, let's see the meaning now so we all learn what it is to help us know when and how to use it. The concept of judicial notice was spelled out by Lord Sumner in the case of Commonwealth Shipping Representative versus P&O Brand Services that judicial notice refers to facts which a judge can be called upon to receive and act upon, either from his general knowledge of them or from inquiries to be made by himself, or from his own information from sources to which it is proper for him to refer. In Ghana, the provision of the law that governs judicial notice is the Evidence Act 1975. By Section 9 of the Evidence Act 1975, NRCD 323, only facts in issue or facts which are relevant to facts in issue are what judicial notice are taken of. More importantly, the same Section 9 provides two tests to ascertain which facts judicial notice can only be taken off, and these are facts so generally known within the territorial jurisdiction of the court, or facts so capable of accurate and ready determination by resort to resources whose accuracy cannot reasonably be questioned, that the facts are not subject to reasonable dispute. In the case of Mensah and others versus the Republic 1979 GLR 523, where the trial judge took judicial notice of the fact that the economic ills of the country were due to world inflation. In returning the decision of the trial judge on appeal before the High Court of Justice, the learned judge, Cecilia Cranton-Addo, J., as she then was, explained what is meant by judicial notice in the following words. Judicial notice referred to facts which a judge could be called upon to receive and act upon, either from his general knowledge of them or from inquiries to be made by himself for his own information from sources to which it was proper for him to refer. To take judicial notice of a fact, however, the judge had to be convinced that the matter was so notorious as not to be the subject of dispute among reasonable men, or that the matter was capable of immediate accurate demonstration by readily accessible sources of indisputable accuracy. Concluding, she held that the facts which the trial judge took judicial notice of in the instant case could not be classified under this definition. Although world inflation was a matter of public notoriety, the extent to which the word inflation affected each country was not a matter of which judicial notice could be taken. Furthermore, a court was not the proper forum for the evaluation of economic factors which contributed to inflation. At the end of our Did You Know episode 6 today, we have all come to learn what is meant by judicial notice, and by way of breaking it down, judicial notice as a term in law deals with facts received by the judge, of which it is generally known by the judge, or which the judge receives and inquires into them for information, relying on sources which are proper and there is no dispute surrounding the state of affairs of that matter. Judicial notice must be on the facts in issue or relevant to the facts in issue. Hence, combine the test laid down in Section 9 and the decision of her ladyship above to get the full test for holding the matter to be judicial notice. In all, adding up to what her ladyship said on when judicial notice could be taken, see Section 9 for the time judicial notice could be taken and the manner in which it could be raised and admitted. Thank you for joining us once again here. Please do well to subscribe to this channel, like the videos, write down your comments, and share to friends and families. We promise you more exciting content coming soon, in addition to what we have already begun. Thank you all and have a wonderful day.